filings, I am not receiving them or accepting them. They are late. They were late at the first hearing. They are late at this hearing. They are extremely late. And then the court did go over with you. I understand you may be ill or may have been ill. However, the court received no correspondence from you, nor did Mr. Justin, from July 20th until August 7th. And again, I'm going to tell you, if you received a call from the clerk, she's not your lawyer either. You have to figure it out. You've been through 3, 4, how many lawsuits with other people involving this house? You've had lawyers, you've not had lawyers. You've represented yourself. You're representing yourself in the Court of Appeals. You should know how to do it, or don't, and get a lawyer who knows how to do it. This is extremely late. It's not forgiven. It's unreasonable that it is this late, especially when the court went over it with you. And again, you filed it again as exhibits, which cannot be seen. And then the court finally gets a copy where I can review it on August 7th, in which the court, I was not even in court that day. I was off due to a family function on August 7th. I get back yesterday and I have a quote unquote short brief of 12 pages of writing, but total of 258 pages. Not only can I not get through it because I had a full day's calendar, I'm sure Mr. Justin had no ability to get through it either. 258 pages, and you expect the court to review it and be prepared for the hearing? Can't happen.
And they're all hot. They don't make it out of like Jersey fabric.
All right, can you hear me, Mr. Justin?
Good morning, Your Honor. Yes, I can.
Good morning. Okay. We will go on the record in the matter 26 CV50, Tony DiNardo versus Structural Buildings of Minnesota et al. We have Ms. DiNardo appearing in person with co-plaintiff Scott Vogel without counsel. We have appearing by video conferencing with approval of the court, Roger Justin, counsel for Structural Buildings of Minnesota. We're set here today in this matter for a summary judgment hearing. We were originally scheduled for a hearing on July 20th, 2026, in which the court did hold the hearing. Ms. DiNardo did come to court. She was ill and had been ill for a while. She indicated to the court that she had made certain filings in response, but she wasn't certain as to any deadlines or whatnot at that time. She did file things, but they were filed as exhibits. So neither the court nor Mr. Justin were capable of reviewing or looking at those documents, because the court nor other counsel gets access to see those documents until they are offered to the court, and the court does receive those exhibits, and then they are magically put into the e-filing system for my review and for other counsel or other parties' review. The court explained that and went over that with Ms. DiNardo at the hearing. She requested an adjournment, although hesitant, I would say, or not completely on board. Mr. Justin did not strongly object and was okay with adjourning this matter to another date and time to allow Ms. DiNardo to make the proper filings. She stated she needed to go home right away, and then she would be able to file them as documents and not as exhibits. The court went over the deadlines with Ms. DiNardo that must be filed within 5 business days per statute, as well as court rule, 5 business days at least prior to the hearing. The court did not receive, or the court received a letter from Mr. Justin on August 6th, in which he was objecting to any filings from Ms. DiNardo or Mr. Vogel because they were late. And the court went over the deadlines with Ms. DiNardo at the time of the initial hearing. So he did object to any filings as being late. Then the court did receive correspondence from Ms. DiNardo, a letter clarifying an e-filing of summary judgment materials. And then that was on August 7th. And then later on August 7th, the court did receive, and I quote, plaintiff's short brief in opposition to defendant's motion for summary judgment. 258 pages long. 258 pages is not short, nor is 12 pages, which is the initial brief. That is not a short brief, but the court did receive that on August 7th, along with an affidavit from Ms. DiNardo and Ms. DiNardo and Mr. Vogel at that time. So we are here today. Mr. Justin, this is your motion. We are here for the summary judgment in which you have made certain arguments in your initial filing for some summary judgment. The court has received and reviewed that in its entirety. I'm going to have the parties, Mr. Vogel and Ms. DiNardo, please stand up, raise your right hands. You're going to be sworn in.
Do you affirm that the testimony you're about to provide in this matter should be the truth, the whole truth, and nothing but the truth?
Yes.
You may be seated. All right, so Mr. Justin, this is your motion for summary judgment. You may begin.
Thank you, Your Honor. I would just like to talk about two things. That one you already noted, the second that I brought up in my brief. I would like the caption.
I'm going to stop you just 1 second. Can you hear him okay? You're kind of like muffly. And I don't know why. I turned you up on the system, but it's still kind of muffled.
Okay, I'll try to speak louder. Is that better?
Well, yes. And I turned the system way up. So if it starts to screech, I'm going to have to turn you back down. But all right, you may start over.
Okay, thank you, Your Honor. I just want to touch on two things before I get to the substantive argument. The first is that I noted in my brief that the defendant's name on the lawsuit should be corrected to Structural Buildings of Minnesota, Inc. I didn't see any objection to that from plaintiffs, so I would ask for confirmation that that will be occurring.
Let me just take care of that and handle that right now. Do you object to having the name changed to include Incorporated, Inc.?
No. we don't
All right. It is stipulated to the court will grant that and will amend the name to Structural Buildings of Minnesota, Inc.
Thank you, Your Honor. And then secondly, the court already noted that I objected to the late filings. I remain with that objection, but I'll make the substantive arguments nonetheless.
And yes, I'm going to have you do both.
Okay. In relation to the substantive arguments, I'm going to briefly go over the facts. Plaintiffs in this case contracted with Aero Building Supply or Aero Building Center. I'll just call them Aero. That was December of 2020. That was for work to be done on their home. Problems apparently arose early in that project, and in June of 2022, they entered into a repair agreement with Aero. That apparently didn't go very well either, and the affidavit that Mr. Vogel signed and they filed in this case talks about the issues that they had with the construction.
I want to stop right now. What affidavit are you referring to?
Along with the short memo they filed, Mr. Vogel filed an affidavit.
Well, I'm going to say that if your argument is the court not rely upon that because it's late, perhaps you shouldn't be relying upon that in your argument.
Okay, I will do that. And I'll say the complaint in this matter alleges various violations and that all of those issues occurred at the latest June of 2023. Now, after June of 2023, Arrow sued for payment, and plaintiffs in this matter issued a counterclaim. That counterclaim was filed in that other matter in August of 2023, after any work by Structural or Arrow had been stopped. They have that lawsuit. The result of that lawsuit is a mediated settlement agreement of December 27, 2023, which is the issue and the heart of our motion. Our motion is that they knew of all the damages before that mediated settlement agreement, and they released all their claims through that mediated settlement agreement, through which they were represented by counsel the entire while.
And so we can have it clear on the record, are you referring to Burnett County case number 23 SC 213 Ingstrom Construction Inc. versus Scott Vogel et al.? Or USLBM Holdings LLC?
Yes, that's the file.
All right, so that would be 23 CV 90, which is 23 CV 90, which is USLBM Holdings LLC versus Scott Vogel et al. The court will take judicial notice of that matter.
Yes, and that, at least the counterclaim, and that the answer and counterclaim is Exhibit 2 to the affidavit that we filed in this matter. So they enter the mediated settlement agreement. The lawsuit was dismissed. The crux of the argument that we have, it's Exhibit 3 that we submitted with our motion, and plaintiffs submitted the same document as part of their responses here. But paragraph 9 is the one we're relying on. It says Vogel and DiNardo shall never file a lawsuit, grievance, or administrative proceeding that arises out of or relates to any and all claims or damages released in this agreement against Arrow or against any other person or entity that arises out of or relates to the claims released in this agreement. They're releasing everyone for all time from any claims that they had. So, or any claims that they released. So we have to look at what claims were released. Now we go back to paragraph 6 of that same agreement. It's titled Mutual Releases. And I am not going to read that entire page of which claims were released.
I'm just going to say, you probably can't see, but I've read it. I've highlighted or underlined what I've read and found important to it. So you can argue and know that it has been reviewed and read.
Okay, great. Thank you, Your Honor. So they list with specificity which claims they were made in painstaking specificity, I would say, for a mediated settlement agreement. But it gets down to the point where it's all claims, all damages, consequential or incidental, known or unknown, asserted or not, counterclaims, damages, defenses, contract, tort, warranty, whether in law or in equity, known or unknown, asserted or not. It's everything. And that it indicates to me that the parties were a little tired of arguing what was being released. And you go to the final sentence of paragraph 6, and it says this mutual release is intended to be full, final, and global between the parties for all of their project dealings now and forever. Amen. I've never
I loved that.
Never
I
seen
loved it.
in a settlement agreement before, an agreement before. Everything is going to be gone. In addition to that, if you want to say that that's not clear enough, you go back to paragraph 1 of the mediated settlement agreement. And it says, this is the spirit and intent of the agreement. And again, it's all claims asserted or unasserted, the entirety of their claims, known or not unknown, asserted or not, in any way relating to the construction, repair, contracts, and the project. They're giving up everything that they had. Now, they're not giving it up for nothing. They got $105,000 to do these repairs, but they have released through this document all of their claims for wrongful acts relating to that. And the fact that years later they come back without an attorney and possibly with the help of some AI program to come up with an argument to say that this is, you know, it doesn't mean what it says it means, I would say is disingenuous at best. They had claims. They hired an attorney to prosecute those claims. They made a recovery on those claims, and they released those claims. And it's our position that this is unambiguous, that there is no merit to the claim that there were unreleased claims that they're now pursuing, and summary judgment is appropriate. There is no further discovery needed because the release moots out any of that. And if there are any questions, I'd be happy to answer, but I believe that's our position.
All right, thank you. I believe that is almost precisely what you argued in your brief, as well as which is supported in with the mediated settlement agreement. All right, I'm going to turn to Ms. DiNardo. You seem to be the one who's taking the lead in these matters and the actions that have been before the court. First thing is with regards to late filings.
Yeah, I do apologize, Your Honor, and in all due respect, when I did file, when you go and look into the filing choices, it made sense to me where it said plaintiff's pre-file exhibit, and then the other option was file a document. It's taken me up until third time around now. Now I understand 100% that my original filing was the original filing. This now is the document that belongs with that. It took me until filing the second time when I called the clerk and she was like, Tony, you did it again. And I'm like, oh my goodness. And so that is what happened. And that was a 100% misunderstanding on my part. I had no idea. I know we discussed it during the hearing, but that
Went over
part
it
of
very
it.
clearly. Exhibits are nothing that can be seen at all. You have to file it as a document.
I was so sick that day. I was cloudy. That's the only thing that I can share with you on that. And
Why did it take you from July 20th to August 7th to all of a sudden figure it out? And I did not receive a doctor's note, by the way.
Oh, you know what? I will get that for you. I will still get that for you. I honestly, that day I was so sick, I couldn't remember if we discussed 5 business days, 5 days. I started having second conversations when I've been talking to the law library. I just started having second guesses, and that's why I sent the email to Mary Henricks.
She's my assistant. She's not your lawyer.
Understood. And so because I looked at the meeting minutes and I didn't see if it said how many days, if it was specific to business days and,
Did you read the statute, which is very clear, Wisconsin statute 801.15, 5 days before the hearing, business days. It tells you even how to calculate it. Wisconsin statute, very clear. 5 business days.
you're right, you're right, Your Honor.
Well, with regards to the filings, I am not receiving them or accepting them. They are late. They were late at the first hearing. They are late at this hearing. They are extremely late. And then the court did go over with you. I understand you may be ill or may have been ill. However, the court received no correspondence from you, nor did Mr. Justin, from July 20th until August 7th. And again, I'm going to tell you, if you received a call from the clerk, she's not your lawyer either. You have to figure it out. You've been through 3, 4, how many lawsuits with other people involving this house? You've had lawyers, you've not had lawyers. You've represented yourself. You're representing yourself in the Court of Appeals. You should know how to do it or don't. And get a lawyer who knows how to do it. This is extremely late. It's not forgiven. It's unreasonable that it is this late. Especially when the court went over it with you. And again, you filed it again as exhibits, which cannot be seen. And then the court finally gets a copy where I can review it on August 7th, in which I was not even in court that day. I was off due to a family function on August 7th. I get back yesterday and I have a quote unquote short brief of 12 pages of writing, but total of 258 pages. Not only can I not get through it because I had a full day's calendar, I'm sure Mr. Justin had no ability to get through it either. 258 pages and you expect the court to review it and be prepared for the hearing? Can't happen. This is a court. I am a judge that reads and reviews everything prior to coming into this court. If you don't know how to do something, you have to hire somebody else, an attorney, to do it. The law library is not your lawyer. They cannot instruct you how to do it. My assistant is not your lawyer. She cannot tell you anything on how to file or what to do. The clerks are not your lawyer. You cannot get information from them. You have to figure it out. Your filing is late. It is not received by the court due to its tardiness. However, you can respond orally to the arguments made by Mr. Justin.
First, I just want to, I do want you to understand that we have been attempting to retain an attorney because of the mess the 4 attorneys have created. We can't get an attorney, we can't find one. So
I'm sure no attorney wants to pick this up with a 1,000-foot pole or
No.
touch it.
Mhm.
This is, I don't know if this is 4 or number 5 lawsuits that you filed or cross claims with contractors regarding your home. And with how one went, which is in the Court of Appeals right now, I can't see, you would need to go far, far away to get an attorney probably. Attorneys talk to each other. They don't want to take a case that seems messed up and very disorganized. So with regards to Mr. Justin's arguments as it relates to the fact that this doesn't even come or should not come before the court, it should be granted summary judgment because of the mediated settlement agreement and what it clearly says. What is your response?
Well, Your Honor, so Structural Builders is asking the court to end the case without, in the matter of law, before having any depositions, going through the entire process. First of all, Structural Builders was not the original builder. Arrow Building Center actually built the home. They weren't remodeling. They didn't come in to just do corrective work. They built our home, and that was in 2021. When they came in to build the home, there were multiple violations from the beginning of 2021 all the way up until we decided to bring in architect Craig Sealander in November of 2022. Brought in Craig Sealander because now all of a sudden we're finding out that there's no footings under the common wall holding our house up. There were architectural changes. There was no res check done before the plans were finalized. So with that being said, in November, when Mr. Sealander was hired, he provided a full report. In following that, in June, we met with, that's when we had Sorrow as an attorney. We paid $25,000 more, even though that there were violations that were filed with the state. We were required to pay $25,000 down in order for Arrow to even put us on the schedule. The meeting had.
Just before you continue, did you read Mr. Justin's memorandum in support?
Yes, I did.
And so in paragraph number 3, he states Structural Buildings of Minnesota, Inc., structural. That's what they'll be called throughout the rest. Entered into a subcontract with Arrow to perform work on that project. So the defendant here is a subcontractor of Arrow, the contractor that you hired to build your home. You agree with that?
Correct.
Okay.
What I do want to note is when we filed the claim with Department of Safety and Compliance, they learned that Arrow did not have a subcontractor's license to hire.
Well, that's neither here nor there. You've already resolved, and if you wouldn't have brought this case, all the things would not be able to speak about anything, but you resolved everything with Arrow lickety split, and it kind of took care of all claims and all allegations and all things you said, and I quote, full, final, and global between the parties for all of their project dealings now and forever. Amen.
And part of that, with that agreement, so when we were in mediation, subrogation was still in the midst of everything. While we were at mediation, they came in, asked us if there were any other contractors, who else was involved, and I had advised them that subrogation was still underway. And we had conversations with our attorney. We were not under the impression that we signed a global release that day, or even after. We asked why we were not filing any lawsuits against structural builders. This claim that we have is its own claim. It's from the June 22nd agreement.
Understand what a general contractor is and what a subcontractor is, and that a sub
Yep.
just means, hey, we're under the general controls how the project is being managed, and they say, hey, I'm gonna direct you, subcontractor, to build this part of the building. I'm still in control, I'm still the general. I still handle all of the things,
Yep.
but I'm delegating this part of the work to you. You understand that process?
I do.
And it looks like you had a lawyer for 23 CV 90. List 2, actually. No, it lists 1, Ross Hussey.
Mhm.
You had a lawyer. So when you entered and signed into this agreement, you had a lawyer, correct? Yes.
Yes, Your Honor.
So how and why do you believe that the mediated settlement agreement does not umbrella and cover the subcontractors, anyone working under Arrow? How and why do you believe that?
They weren't there during mediation. They
They don't
didn't.
need to be. It's the general who's in charge. Remember, general sub.
Right.
So why would you believe that? And having an attorney is very experienced. Mr. Hussey is experienced. Why would you believe that you can go after the general and still have claims off of all of the subs. You had a lawyer, so the lawyer should have went over it with you and explained it
Mhm.
very clearly.
That he should have done.
He should have or he did.
He should have. And when you look at the release of claims with subrogation, they only released Arrow. They didn't release our own personal claims.
I'll let Mr. Justin make an argument off of that, but I've read this mediated settlement agreement. I've read, I don't know how many in the course of my legal career and as a judge. This is a pretty good one, pretty thorough. Amen. So I honestly don't think I need any more argument because this is very clear. When the court has to look at a legal document, I have to look at what's called the four corners of that document. And I have to read that document and I have to see if all of the words I have to look at their plain meaning of those words and what they mean and what they say. And this document is very thorough and it's very clear and it goes over all of the things, all of the people, anyone who's ever been connected to Arrow with this construction build. They're released from all future known, unknown, any claims that may pop up in 20 years that you didn't know about. Everything now and forever. Amen.
Says here in paragraph 9, because
Shall never file a lawsuit, grievance, or administrative proceeding that arises out of or relates to any and all claims and or damages that are released in this agreement, and further agree that they shall not authorize any person or entity to institute such lawsuit, grievance, or administrative proceeding against Arrow or against any other person or entity that arises out of or relates to any claims that are released in this agreement. Anything and everything forever, amen. And quite honestly, because of this agreement and because you're bringing lawsuits, they could go after you for attorney's fees. And I'm sure Mr. Justin is worth every dollar he's put into it. And I am going to tell you that I am quite familiar. I don't know Mr. Justin, but I'm quite familiar with his firm because I used to work at Burkuski, Hansmeier in St. Cloud, which is not too far. So there's nothing here. They win. The agreement is locked down. It is solid. There is not any wiggle room. I have read and reread this agreement multiple times. I've highlighted it. I've written notes. I've underlined portions. Whomever drafted this agreement really wanted to make it ironclad against Arrow and anyone under Arrow. Again, that umbrella. Arrow's the umbrella under, and they cover everybody under them who touched this construction project. So again, as I've stated in former actions of yours, your claims, which can't go towards the people you want to go to, really point to somebody else or something else. If you think that there are issues here and you think that you weren't told things that you should have been told, or things weren't explained the way they needed to be explained, or they didn't sue the correct or assert the correct allegations and claims against the parties. But it's not, your claim can't come against structural buildings. Inc. It just can't. So based on that, I am going to grant you summary judgment, Mr. Justin. I don't know. I feel for you. Honestly, I feel for you. It sounds like from day one, this has been a nightmare. And in looking at the litigation that has been filed and the then counterclaims that have been filed back and forth between you and contractors, it doesn't appear that much was done correct. And unfortunately, the more you move through this, the more all the claims are settled, you're left with what you're left with. And it is what it is. I feel for you. It sounds, again, like this was a nightmare construction project.
We don't have a house that's structurally sound.
I don't know what to tell you and what to do about that, but as far as it relates to Arrow and anyone under Arrow, that is, it's already handled. And we'll wait to see what the Court of Appeals says as it relates to that other contractor, but I don't know where you go from here. So, all right, Mr. Justin, it's dismissed. I don't know if you put, it's granted, so then the matter is dismissed. I don't know if you've put a proposed order in the queue or in my file, but if you haven't, please do so, and I will get that matter signed shortly.
Yes, I will do that, Your Honor, and I will, to alert the court, the order will grant the motion, but I would like to keep the case open, not dismissed immediately, because I do want to talk to my client if they want to bring an action for sanctions.
Well, Mr. Justin, I will do that and I will leave it open because you're the one who's requesting it and it's your motion. That is it is his client's every right to try and go after you. He says sanctions, but to try and get attorney's fees and anything else for violating the agreement that you entered into. Mr. Justin, it sounds like this house has been a living nightmare for the parties. Perhaps there could be some leniency here. So talk to your clients and talk to Ms. DiNardo and Mr. Vogel, and hopefully the matter's not made worse for either side.
Understood.
All right, I will allow it to be held open. But Mr. Justin, just let the court know if there's been any settlement negotiations or any decision on your client's part, whether or not to dismiss.
I will do that, Your Honor. Thank you.
All right, thank you. We are adjourned.
Thank you, Your Honor.
Thank you. We will go on the record in the matter 24 CM 196 26 CF 42 State of Wisconsin versus Scott Lang. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Lang in person in custody without counsel. We're set today in this matter for two reasons. In the 24 CM matter, Mr. Lang is requesting, he has motioned the court to modify his sentence. He's asking to have the court reduce his sentence for various reasons. And in 26 CF 42, he's asking the court to modify his bail that has been assessed, his bail for that matter. Mr. Lang, I believe that we have been able to locate an attorney to represent you on the 26, the felony matter. So we can go over that after we're done here today to make sure that you understand what's required, et cetera, and then the court can appoint that attorney. Mr. Schmidt, well, first I'm going to ask Mr. Lang, can you tell the court why you are asking for the sentence modification?
Well, we're in the process of selling our house and trying to clear the property. And my wife just can't do it alone. I mean, there's tons of things that's left to be done. Legal, the paperwork, paper trail that needs to be done. Just basically that. I mean, the longer I sit here in jail, we'll probably be stuck here in Burnett County for another year. And I don't want to risk it with all the negativity that we've been experiencing.
All right, so, well, first off, we're victims' rights compliance for both matters?
Yes.
Okay, thank you. So Mr. Lang, you are looking at selling your home that you have in Burnett County,
Yes,
and you haven't listed it for sale yet?
we have a couple of private interested buyers.
Okay, and so you have something lined up, but what do you have to do for the property before you can sell it?
We still have tons of things on the property that need to be cleared out. I still have some repairs left to do. It's just a ton of things. And of course, there's paperwork, stuff that needs to be signed, that I need to sign, that
So you're not selling it, excuse me, as is?
yeah, we're selling it as is.
So then why would you need to do things to the property?
Well, we gotta clear it off.
What do you mean clear it off of your property?
Yeah, there's cars, trucks.
Again, if you're selling it as is, they take the property as is with all the cars and trucks that don't work and all the junk and all the garbage.
Well, no, they're not all junk.
Okay, so yeah,
Well, I'm clearing the property no matter what, because I'm not gonna be living there once
okay.
I am out of jail.
All right. Mr. Schmidt,
I think the court should deny the motion to modify the sentence. I don't think the court has to even need to get to addressing the merits of what was articulated either in the motion or here today, because as a matter of law, a court can only modify a sentence if one of two things occurs. First, if within 90 days of sentence, there's an argument that the sentence was unduly harsh or unconscionable, it's been more than 90 days, and there's no argument the sentence is unduly harsh or unconscionable. The second is if there is a new factor highly relevant to the sentencing that originally occurred that was either not known at the time of sentencing or not in existence, though known to somebody. The factor that the defendant appears to be articulating is that he wants to sell his house and he wants to do it within the next 30 days prior to his sentence completing. That's just not a new factor. That fits more into second thoughts or what's called subsequent reflection, which the courts have said cannot be a basis for modifying a sentence. That's State v. Grindeman and State v. Masaman. In particular, the action of wanting to dispose of our property was specifically rejected as a basis as a new factor. In State v. Prager, which is 2005, WI App 95. In that case, the husband wanted to get rid of his interest in a farm to his wife, and that was articulated to be a new factor, him being able to support his wife and children. The circuit court agreed and did a resentencing, and then the Court of Appeals reversed and said that as a matter of law just isn't a new factor. I think this is very similar to Prager, and I don't think the court can modify the sentence based on that. Thank you.
great, thank you. He's accurate, and that is very clear case law. And so there isn't a basis for the court to be able to grant your request. I don't think that you have too much longer on that sentence anyway. I think it's a couple weeks, if I'm recalling correctly. So I have to deny that request. If the state wouldn't have made any objections, arguably, perhaps modification could have occurred, but they are objecting, so I must follow case law and what the law is telling me to do, which is I have to deny the request.
Well, the original plea bargain was only for 4 months.
It doesn't matter what the plea was, the court sentenced you.
Right.
So that's what the sentence was. So with regards to that, your motion is denied. As to the bail modification request, anything else you want to add? But you're selling your house and you want to get out to try and be able to do that once you're able to post bond or post bail. But I don't believe there's no contact with your wife still.
I don't even know what's going on. So much lawfare, I can't keep up with it.
Because she's RL. And I believe in the amended bond, it just says no, well, you may have telephonic contact with wife RL. So you can talk to her. I believe she is currently in the courtroom, and Ms. Bauer is here. Ms. Bauer, has she done the CRA class? Yes. She says,
Doing that now.
notice of, and Mr. Lang has done the DV class with Mr. Hatch. So does the state object to having no abusive contact?
If they've both done the class, I have no objection.
If and when you are released, Mr. Lang, the court will amend bond right now and say no abusive contact with RL. As to modification, I guess we have a victim trying to come in. I recognize her name, I believe, MR.
Yeah.
And that's the victim in the misdemeanor case that we just addressed.
All right, MR, the court did not see you waiting to come in and quite honestly did not recognize that you were a victim of a matter. To catch you up to speed with regards to the motion to modify sentence or to have it amended and reduced, that matter was denied. Is there anything you would like to add as the victim in the misdemeanor matter?
I was just gonna ask that it be denied. So no, if it was denied, I'm okay with that. Thank you.
All right, so now on to the monetary portion of the bail that's been set for the 26 felony matter, Mr. Schmidt.
If he's incapable of posting the 500, I don't fundamentally object to reducing it to a lower amount. The fact the court set it at such a low amount tells me the court wasn't intending for that to be the keys to the jail. So if he truly can't post, I don't object to reducing it to a lower amount.
Well, I don't think he cannot post it now because he's in custody.
Well, he could post it, it just wouldn't be in his best interest to post it because then he wouldn't be double counting credit.
Good legal advice, district attorney.
I wasn't saying it to him, I was saying it in general.
As to the monetary amount, I don't know if we know if he can post it or he can't post it. However, you've been in custody. So I will modify it to a $500 signature bond. I don't believe we have any request for restitution in that case. I'm not seeing any supplement in the felony matter. Is there a request for restitution?
Not to my knowledge.
Okay, all right, so I will reduce it to a $500 signature bond, same conditions with that modification of no abusive contact with RL. So once you are released, you have the ability, you can go home and you can have contact with her, just no abusive. That means no yelling, no swearing, no spitting, no shoving, no cursing. And if it gets to a point where you're in a disagreement, just walk away. Okay, Mr. Lang, the court has reviewed your application for the appointment of an attorney. I Another reason I modified to a signature bond for your bail is because you will have to post an amount to retain the attorney through the county. And so that will be $500 that needs to be posted down. And then it will be $100 per month after that. Your wife is here. Do you know when you could post that $500? Because once it's posted, the court can appoint an attorney. Okay, so once we have that posted, I will appoint an attorney. I'm appointing an attorney out of Minneapolis. And so he is a good attorney and he's out of this area, so he shouldn't be too familiar with whatever negative things that you're talking about or you were referencing in your request for the bond modification or the need to get out of this area. And so once that is $500 is paid, he'll be officially appointed to the case, and then he can take over and handle that preliminary hearing on September 11th. His contact information will be sent to you. And once he is appointed, I will have my assistant inform him to contact you in the jail as quickly as he can. Okay?
Thank you.
All right, so the next hearing is September 11th at 9 a.m. I'll get an order out for that, for the appointment of the attorney. Again, once the deposit is made, and then that will have his information on it too. So RL, it's going to be sent to County Road Z. That's still an address that you can receive? And so you'll get that official order that says his name, his contact information, and also the monetary amount that you would have deposited and the $100 a month. The $100 a month will begin in September. Okay, because once you have the $500 down, we can wait until September, or I'm okay with waiting until October if that helps out too, to start
Can I
that.
get the contact information for him here in the jail? while it's
Yes.
clear?
Yes, my assistant will send that up to you.
All right, thank you.
Okay, thank you. We are adjourned. Who's in custody?
Gary Butler?
I don't have you on my calendar.
Okay. I don't know, they just told me to come in here, sorry.
Can you spell your last name?
Butler?
And what's your first name?
Gary?
Gary. You don't have, it's September 11th that you have a hearing.
Oh, okay.
Okay, so September 11th, we'll see you then.
All right, thank you.
We will go on the record in the matters 26 TR 203, 204, 205, and 206. State of Wisconsin versus Tiffany Nutt. Appearances are we have the state appearing through District Attorney Kevin Schmidt in person. Adam Benson appears in person. His client is excused from appearance as this is a traffic matter. Mr. Benson, have the parties reached an agreement?
We have, Your Honor.
And this is after full review of the video and the discovery?
Yes.
And what is the agreement that's been reached?
She will enter a plea to OWI first. The prohibited alcohol would be amended to 0.149. Dismiss and read in the remaining tickets.
All right, that's the agreement, Mr. Schmidt?
Yes.
Formal motion to amend the blood alcohol to 0.149,
So made.
granted. How does she wish to plead?
No contest, Your
Court
Honor.
will enter a plea of no contest on her behalf. The court will dismiss, but merge in 26 TR 205, the PAC. The court will dismiss and read in the other matters. The court will order $968 in fines and fees plus a $10 blood draw fee, 6-month revocation of driver's license with credit for any administrative suspension she may have received. The court will also, I believe it's 6 points off of her license or on her license or however Wisconsin does it. Anything, and the OWI AODA assessment and follow through. Anything that I'm missing, Mr. Schmidt,
No, Your Honor.
Mr. Benson?
No, Your Honor, thank you.
Maybe. Good to go. So thank you. We are adjourned.
What happens when a courtroom argument comes down to one document, and the judge believes that document leaves absolutely no room for interpretation? That is exactly what happened in this hearing. The first case involved a construction dispute between the homeowners and structural buildings of Minnesota. The plaintiffs argued that serious problems had occurred during the construction and repair of their home. But the defense came into court with a major argument. The plaintiffs had already settled these claims. The judge immediately had another issue to address. The plaintiffs had submitted their materials late. Their filing was described as a short brief, but the judge pointed out that it was actually 258 pages. The court had only received the materials shortly before the hearing, leaving little time to review them properly. The judge was direct. She explained that the deadlines had already been discussed at the earlier hearing, and that the plaintiffs had been given instructions about filing their documents correctly. Because the filings were late, the court refused to accept them as properly filed evidence, although the plaintiffs were still allowed to respond orally. Then, the defense presented the heart of its case. According to the defense, the plaintiffs had entered into a mediated settlement agreement in another lawsuit. That agreement contained extremely broad release language, covering claims connected to the construction project. The defense argued that the plaintiffs had already released their claims, and that they couldn't now bring another lawsuit against a subcontractor connected to the same project. But the plaintiffs disagreed. They argued that Structural Buildings was a subcontractor, and that their current claims were separate from the claims resolved in the earlier settlement. The judge then started pressing them with a very important question. If you had an attorney when you signed that settlement agreement, why do you believe the agreement doesn't cover the subcontractors? That question put the plaintiffs in a difficult position. The judge explained that she had read the settlement agreement carefully, and in her view, it was extraordinarily thorough. She said the agreement appeared to cover not only known claims, but also unknown claims and future claims connected to the project. And then came the decisive moment. The judge stated that she had to examine the plain meaning of the document and look at the agreement as a whole. Her conclusion? There was no wiggle room. She said the agreement was essentially locked down and solid, and that it covered the people connected to the construction project under the general contractor. Then the ruling came. Summary judgment was granted. The judge made it clear that the plaintiffs' claims could not proceed against Structural Buildings because of the settlement agreement. But while ruling against them, the judge acknowledged something important. She said she felt for the homeowners and recognized that their construction